Prudent Bank. Immediately after we had been called to the bar, and by the time that I was leaving KOT, Femi was a key factor in affording me the confidence to walk in faith. Prudent Bank was paying 2,000 naira to lawyers for the CAC searches that they were obliged to conduct as part of the KYC and due diligence requirements before they might open corporate accounts. And Femi had been faithful in giving these briefs to friends that had braved going into practice on their own earlier. The meager amount of 2,000 naira per search added up to a tidy sum when it came in a consistent flow, and many a Buhari inmate asked Femi to thank for sustenance in the early days of our law practices. I am eternally grateful to him. I had made the acquaintance of another fellow student at the law school in Buhari. I am unsure of how we might have met now, but Bola Hassan was a very jovial person and is imbued with a selflessness that is pretty rare in this climb. I had been running into Bola in courtrooms since we had left law school, and he appeared to be as much of a courtroom rat as I was. We would gravitate towards each other upon meeting up in court, but then that is a common issue with the first set in Buhari. We developed a bond forged in the furnace of our common affliction in Buhari. Bola's parents owned a commercial building on Sanusi Fakunwa, and Bola was running his law practice named Law Cartel with a K from a rather generous space at the rear of the building. When Bola became aware of my readiness to leave KOT, he made me an offer to join Law Cartel that I could not afford to turn down. I got the use of an office with an address in Victoria Island, a shared clerk, other facilities, and the offer couldn't have come from a nicer person. The arrangement allowed me to trade in my own name or under the Law Cartel banner, and all I had to do was to share the cost of running the office. I was happy with that. I was to remain with Law Cartel until just after my marriage and the birth of my daughter. I moved into the Kota complex in 2003/2004, and it was the beginning of the practice that I had sought to build. Rap Unwoke, it is, that had serially provoked me into what I believe to be the closest I have ever come to defining my jurisprudence and outlining my legal viewpoints. Raf is a legal mechanic. He came to me as an associate in 2006, quickly gained my trust with his legal drafting skills and generally impressive intellectual capacity. He has a prodigious capacity for hard work that remains unmatched by anyone that I have ever employed. And it was for the years that I practiced with him, the professional yin to my irascible gang, or yang rather. Ra knows the law. He is a walking encyclopedia of law and one of the very best commercial law brains that I have ever had the privilege of either meeting or working with. He kept me out of trouble for years. If I have described Raf as a mechanic for his rigid insistence on fidelity with the letters of the law, I must admit that I was the artistic legal brain in the practice that I built. When strict adherence to the letters of the law would not be in my client's interests, and the law allowed the imaginative room within which to legally maneuver, I was always happy to take advantage of the room offered. I will be mulling over what I believe to be an ingenious solution to a client's legal challenges, and having doubts as to the lawlessness of the idea I had settled on. I will use Ralph as the sounding board, luring him into the many passionate disputations that I enjoyed with him over the years. Thing is, poor Ralph assumed for several years that he was always just a step away from being fired for his constant audacity to argue with his boss. What he came to realize is that I was only ever grateful for his courage and looked forward to our sessions. It was during one of our heated sessions that I declared my philosophy of law, and I believe it was also the day that we began to understand the strength of our synergy and the value of efficiency. And the value and efficiency of our then emergent partnership. I explained to him that I did not read law in order to follow the rules. I read the law in order to guide myself and the purveyors of my services through the labyrinthine minefields of the Nigerian legal system. I always knew that Nigeria is built on a foundation of lies, that the country of my birth is iniquitous, unjust, and intricately evil. I had known this from my mother's womb, and I had never harbored any illusions about the existential nature of the evil empire in which we live. I explained how it was the duty of the lawyer to work in the knowledge of this truth in everything that he does for the client. I explained how I relied on his own knowledge of the mechanics of the law to rein in my own worst instincts, which constantly seeks to discountenance the many inane laws and regulations that will restrain the client. Between our two extremes, the clients are usually left with the best of the two worlds. A client came to brief us about a property that the company owned in Ikoyi. Client is a property investment company that has a lot of real estate interest in the Ikoyi axis. The uniqueness of our legal architecture and tenancy laws had created an equally unique problems for them. Recalcitrant tenants that had learned how to exploit the institutional weaknesses of the legal system and the tenancy laws to game the company out of its legitimate business income and expectations. They would owe rent for several years and would happily pay a lawyer to delay the cases for recovery of the premises and the back rent. We put a stop to it. We crafted a clause that has become part and parcel of every tenancy agreement that we have drafted for that particular client. And anyone that has been happy to have the clause incorporated into their own leases that we have drafted, designed as it were for this particular client. I am happy to report it as one of the unique devices that we have employed in the services of our clients over the years. We introduced the re-entry clause into the tenancy lease agreements. The tenancy law have been drafted by men without any understanding of the need to protect the pecuniary interest of the landlord, and most certainly without any thoughts as to businesses that will be investing their capital in the real estate sector. The cumbersome laws and processes have served to prolong suit taken before the court seeking the eviction of debtor tenants, the recovery of the premises, and immense profits. Some lawyers have turned the delay tactics into an art form, and our clients were losing money. The government that has failed woefully in the business of social housing has drafted laws that are overprotective of the tenant's interests and dismissive of the property owner's right. We began to insert a clause that allows the landlord the right to re-enter the demised property upon the crystallization of a failure on the part of the tenant to meet the obligation to pay his rent. Ralph had argued strenuously against the inclusion of what he rightly identified as an unlawful clause, but after allowing him to make his points, I considered the legal soundness of his argument and then explained the legal basis of my decision to adopt the clause, in spite of his reasoned arguments. A man that couldn't afford to pay his rent but would employ a lawyer to delay the recovery of the premises merely takes advantage of the system that has allowed the conditions favorable for his wicked refusal to meet his obligations. When a man has failed to pay his due rent, the very foundation of his occupation of the premises and the condition precedent to his peaceable enjoyment of the demised property will be hard-pressed to explain to the court as to why he should be deemed entitled to any monetary damages above the rent that he already owed. I have used the clause a grand total of 2 times, and none of the evicted debtors have ever managed to successfully sue my clients for damages. The only one that sued recalibrated his senses on receiving the counterclaims and defense to the suits that he filed. I have used this to illustrate the practical nature of the law practice that I built and the lack of any illusions in my engagement with the Nigerian legal system. I was not blind to the objective realities of my environment, and I happily evolved workable solutions to my clients' problems. I built what was to become a lean legal firm that, at its peak, was the biggest real estate law chamber in the country and remains accountable for the bulk of legal precedents used in the real estate industry in Nigeria to date. After the initial years spent essentially as a litigation lawyer, I quite deliberately and consciously avoided accepting litigation briefs. I had seen firsthand the extent of the rot in the court registry. I had seen the impossible caseload of the magistrates and judges. I could see that the judiciary is just as corrupt as any other sector of the Nigerian state. And I wanted nothing to do with the court system for as long as there was the likelihood of a negotiated settlement of the inevitable disputes that our clients ran into. The years spent watching Miami settling the Inolende squabbles became the bedrock of the firm's reputation for complicated business negotiations and disputes resolutions. We actively worked at all times with the deliberate intention of doing everything to avoid going to court. Litigation has always been a last resort in my practice, and from the very foundations, actively discouraged. As my practice evolved and my influence with my clients grew, I increasingly became the person that will provide the legal architecture for transactions from the initial beginnings. I found that the bulk of the arguments and disagreements on the draft would usually come not from the counsel representing the other parties, but from my own clients. When briefed to draw up an agreement, we would always draft blind. We are blind to the identity of the parties, and it would not matter a jot who was paying our bill. I had learned from Miami's feat that however happily a party might appear to concede an advantage whilst under any form of pressure, they would almost always regret the concession granted, and where and whenever possible, they would be looking to break the agreement. I had learned the most important part of any agreement is captured in the Yoruba doctrine of Ti ojuba ye oju, ki ohun koma ye ohun. Consensus ad idem. I have had countless disputations with my clients in defense of the initial draft of the several commercial agreements that we have drafted over the years, and I am happy to have been trusted with a lot of groundbreaking agreements in the real estate sector, which I spent the bulk of my legal career serving. Despite being the preeminent real estate law firm in the country, no legal document drafted by my law office has ever been invalidated by a court, and we have had less than 5 legal challenges to our clients' rights or interest arising from some legal error attributable to our work. I built a practice that knew the wisdom of avoiding Nigerian courts. as Mami was wanted to say, Akiti called today, Kashore, no one comes out of a court case adjudicated in the favor of his opponent with a smiling face. Now, the beginning of the end, chapter 7. As I had said at the outset, I had always known that I would retire from the practice of law once I turned 50 years old. I never knew just exactly what I would be doing with my life thereafter, but I always knew, and I had never failed to communicate this knowledge to everyone that I considered my friend, long before I was called to the Nigerian bar. I had no concrete plans laid out for the remaining days of my life, but I knew I would be done with the earning my living from the practice of law, even when I was most in love with my profession. As the years rolled by, and I began to get closer to the appointed time for my exit from the practice, I began to think more and more about the future, and I sought to imagine and envision what laid ahead for me. Whilst it was easy to settle into the knowledge of my exit without agitating my mind over what would follow when I was in my 30s, the minute I rolled into my 40s, I became more and more concerned about what laid ahead, just exactly what I would do with my life. I had been given the grace of value creation by my creator, and I was confident that I would always find buyers for the scarce values that I have been blessed to search out and to create. I needed not have worried. Eledumare had designed my path from the dawn of time. The day of appointment with my destiny was completely mundane in its dawning. It was the 26th day of May 2013. A Sunday it was. According to the calendar I consulted before commencing this chapter, and the date I had equally confirmed by checking the immigration stamp on my passport. The meeting was at the Heathrow Airport, Terminal 5. It was in the morning. I had traveled out of the country on the 18th of May 2013 to attend to some business in the UK. And as is the notorious case with me, I was in a hurry to return to our asylum. I have missed my flight only once in my life, and I missed the flight not because I got to the airport late, but because I mixed up the dates. I have earned my reputation for always being on time, and scheduled flights are not likely to be missed by me. I had gone through the BA counter, cleared the security checkpoints, and was in the lounge with about a couple of hours to spare, and having had a leisurely breakfast, elected to begin my journey to the departure gates. At the point before one might enter the lift to access the shuttle service, there are park benches arranged on either side of a wide aisle leading up to the lifts. And there, sitting on one, was the doyen of the Nigerian legal system, Are Babalola. The old man had bags arranged around his feet. There was the usual carry-on luggage, and I believe 2 other leather bags. But there were a couple of plastic bags in addition. Baba had evidently been busy shopping at the duty-free shops. The Omo Odoagba that I am, I prostrated like a proper Inolende boy, greeted the old man, and offered my services in carrying his baggage. He gratefully declined, and when I insisted on account of my concern for how he intended to carry so much on his own, he let on that he had helped and was only waiting for some other persons or persons. I bade him farewell and took my leave. Little did I know of the significance of the moment. I usually know, but this time I did not know. The first we knew of the magic being put together by Afe and his elves must have been around the middle of July, probably a couple of days after the Supreme Court delivered its original judgment on the case. The aborigines of the Ajiran or Sakwa axis were whispering about the Ojomu's loss of the case at the Supreme Court. And this was followed by very aggressive moves by Dele themselves. Signboards began to appear all over Osaka, Agungi, part of Nikon Igbokusu, Victoria Park, Friends Colony, and the Pinnock Beach Estates. They were asserting claims to 254 hectares of land, and several clients had called me up in panic. In introducing myself, Chief Babalola described himself as solicitor to the Gbadamoshi Eletu family. And indeed, the family were the appellants in the case. But the question is this: who and what is the Gbadamoshi Eletu family? Who is Gbadamoshi Eletu? This becomes important given the fact that it is the basis of engagement with Chief Babalola, and it is also the point of engagement between the courts and those who claimed rights on the land on behalf of the Gbadamoshi Eletu family. There is no entity known as the Gbadamoshi Bamidele Eletu Chieftaincy family. It is a creation of fraud, and nothing can be found on a claim arising from a fraud. Legends have it, and facts have proven so, that a certain man by the name Major Eletu purportedly purchased 254 hectares of land from the Ojomu Chieftaincy family, and to whom title was conveyed by a deed of conveyance in 1977. Duly registered at the land registry at Alausa. Any and all successors to his title, actual or imagined or contrived, as in this case, must claim solely from these roots. The deed of conveyance is one of the many titles determined by the Gazette of Acquisition of 1993. This was the acquisition, this was the acquisition that was challenged by the Eletus in M/779/93. That was the claim that was definitely settled in the case. This is the case that Justice Akas adopted in the first judgment of the Supreme Court. Upon the death of Mr. Gbadamoshi Eletu, no probate records have been placed before any court. No will. Nothing to indicate what happened to the estate of Mr. Gbadamoshi Eletu. However, those who have presumed to claim land in his name have acted at all times, placing the deed of conveyance of 1977 before the court. These persons might be related to the owner of the land conveyed by the 1977 deed, or they may not be. But as the facts reveal, there is no family in the sense in which the word family is used within the Lagos State Land tenure system. There is no Gbadamoshi Eletu family. I reassured all that any claims by the Eletu to anything more than the 10 acres granted to the Eletu in suit number M/779/93 can only be made in fraud. And I was categorical in concluding that even a Supreme Court bench, wholly staffed by their ancestors, was incapable of giving them the relief that they claimed to have won. I knew this because I had been following the case since the beginning of my law practice, and during my time at Bassa and Partners. I immediately contacted our representatives in Abuja to make the necessary application to the registry of the Supreme Court for the CTC of the judgment and the enrolled orders of the courts, and same were procured within a couple of days. It is amazing how efficient the inefficient registries could become once the process is sufficiently greased. I mean, a cursory reading of Justice Aka's lead judgment was enough to show that the Eletus were up to some shenanigans, and the roots of their mischief became apparent soon enough. Upon studying the judgment itself, in the face of the intransigence of the Eletu family and their continuing refusal to respect the boundaries of the judgment that had been given in their favor, it became incumbent upon us to speak with the Babalola firm and the Eletu family themselves. We wrote a series of letters, both to Oludaramola San, as the head of the Babalola chambers in Lagos, and also to Gbadamoshi Eletu family, specifically Chief Wahid Eletu, and sought to hold meetings with them in order to better understand the parameters of any disagreements or disputes that we might have with them, whilst we continue to monitor what was going on. We had by this time become aware that the head judge in Lagos State, Atilade J, had signed a writ of possession. Being made aware of this, we continued to write letters to the sheriff section and to the Chief Justice, including concerned authorities, to make them